Welcome to the Tech Law Podcast, where we explore legal issues affecting technology companies, from startups to the giants. If it's tech and it's legal, we talk about it here. The show is presented by Pillar Legal. We help tech leaders protect their companies so they can focus on innovation and growth. Hello and welcome to the show. I'm your host, Greg Pilarowski, the founder of Pillar Legal. Today's podcast is the second in a series where we work our way through the NVCA Series A term sheet. In the last one, we talked about valuation, the most important number in the term sheet. In this one, we're going to be talking about liquidation preference, a topic that can have a pretty big impact on the exit proceeds for founders. So this is one you really want to pay attention to. We do have the same content in text format. There's a link in the show notes. So if you prefer to read as opposed to listen, that is an option for you. Starting off, what is liquidation preference? It is a right that attaches to preferred stock. So the stock that your investors receive when they're investing in your company, they'll have a liquidation preference right. And what is that right? It's basically the right to get paid first when there is a liquidity event. What is a liquidity event? It either means the company's getting shut down because it has failed, or there's an M&A exit. There's also the possibility of an IPO, but that's a different scenario in which the preferred stock generally gets converted to common, and the liquidation preference doesn't come into play anyway. So the liquidation preference, it's really about two different things. One, you have an M&A exit, or two, you're shutting down the company. And in either of those situations, the preferred stockholders basically get their money first. And so that's what the liquidation preference is all about. There are, however, multiple different versions of a liquidation preference. And this, as a founder, is what you need to pay attention to. Behind these different versions of the liquidation preference, there's a philosophical debate. In the one hand, there's downside protection. Liquidation preference is the right to get paid first. And so in a situation where the company has failed and doesn't achieve a favorable exit, those investors get their money out before anybody else does. So that's a downside protection. Another version of a liquidation preference not only provides that downside protection, but also gives a boost to returns in a situation where there is a favorable exit. Now, founders naturally don't like this. If there's a favorable exit, meaning that the valuation at exit is much higher than the valuation at the time that the investors put money in, so that the investors are making back their original principal, but also a return on that. From the founder's perspective, there's not a need to have an enhanced return for the investors in that situation. But this tension between, is the liquidation preference for downside protection, or is it for, boosting the return? That philosophical debate is what lies behind the different versions of the liquidation preference. And as a founder, when you're looking at this in the term sheet, you want to pay attention to which variety of the liquidation preference have the investors served up to you. So the two key varieties, one is non-participating preferred. This is founder friendly. This is what you want. In a non-participating preferred liquidation preference, when that liquidation event happens, whether it's an M&A exit or shutting down the company, the holders of preferred stock, the investors, they will receive the greater of either how much they invested into the company or their prorata portion of the exit proceeds. So they get one or the other, whichever one is a bigger number. That's non-participating preferred. That's the founder-friendly version. There's also participating preferred. In the participating preferred, instead of an or, there's an and. So the investors receive their original investment amount back plus and their pro rata portion of whatever is left. So that is the double dip. That's not only the downside protection, that is also the enhancing of the investor's return. So that's more pro-investor, not what you want to see as a founder. There's also a third variety that you'll see in the NVCA forms, which is a capped participating preferred. And this is a hybrid between the two. It's exactly like the participating preferred, except that the return that the investors received is capped, often at 2 or 3 times their original investment amount. So the idea is that the investors would receive on that M&A exit, they would receive their original investment amount back plus their pro rata portion of whatever is left, but capping that at say 2 or 3x whatever their original investment amount was. So working through an example, keeping similar numbers to what we had in the last episode on valuation. In our hypo, and you'll see this in the text version as well, so you can follow along with the numbers there. We have a $1 million investment at $10 million post-money valuation. So we're just using these numbers to keep it simple. So in that cap table, the investors would own 10% of the company. The founders plus the team through whatever ESOP is in place would own the remaining 90%. So $10 million post-money valuation. And then we have an M&A exit at $15 million. So it's a positive exit, not out of the park positive, but the valuation at that exit at $15 million is greater than the post-money valuation at the investment time. So it's a positive exit. Looking at the 3 different varieties of liquidation preference. In the first one, the non-participating, if it's a 1x non-participating, that means the investors, they would receive back either their original investment amount, which is $1 million, or their pro rata portion of the M&A proceeds. So 10% of that 15 million, that's 1.5 million. That's more than 1 million. Therefore, in the 1x non-participating preferred situation, the investors would receive 1.5 million. The founders and team would receive the rest, which is 13.5 million. In a 1x participating preferred, there the investors would receive first their initial investment amount of 1 million plus their pro rata 10% of what is remaining. So 10% of that remaining 14 million. So that's 1.4. So 1 plus 1.4, the investors would receive 2.4 million. And then the remaining 12.6 would go to the founders and the team. In the a capped participating preferred, let's say we cap it at 2x, in that situation, the investors would receive their 1 million investment amount initially, and then instead of getting 10% of what is left, instead of getting another 1.4 on top of that, they would be capped and get 1 million out of the remaining proceeds to receive a total of $2 million, with the founders and team receiving the remaining $13 million. So from this one clause in the term sheet, the liquidation preference, in this hypo, you can see that there's a pretty significant difference in the outcome for the founders. The founders and the team would get 13.5 million in the most favorable situation and 12.6 million in the least favorable situation. So it's a swing of a little over $1 million. That swing in how much money is in play can obviously be much more in situations where we have different hypothetical numbers. So the key takeaway here is that the liquidation preference matters. And you want to have that most founder-friendly one, if you can, the 1X non-participating preferred. Now, another interesting thing to keep in mind is here we're talking about a Series A term sheet. In later rounds, Series B, Series C, if you continue to successfully raise funds, those liquidation preferences stack. And so there's two different ways that the liquidation preferences can generally stack. One is that all the preferred shareholders receive their liquidation preference on a prorata basis, irrespective of class, irrespective of when they come in, which is more common in what I see is whoever puts their money in last gets their money out first. So the Series B, which come in after the Series A, would tend to have their liquidation preference paid before the Series A gets paid. So, if you get to a Series D financing, at that point, there's liquidation preference for D, for C, for B, for A, and then sometimes Series C, and all of that gets paid before anything goes to the founders and the team. So depending on which liquidation preference is in place, this can have a material impact on the ultimate return for the founders and their team. Our good friends over at Carta, the guys who run those handy dandy cap tables and help with 409A valuations, they have a lot of market data and they share that data. Thank you, Carta. And their data shows, as of a couple of years ago, that the most common liquidation preference of the three different varieties is the 1X non-participating preferred. That's 70% of Series A deals has that 1X non-participating preferred, and that's what you as a founder really want. Now, do you get the participating preferred in some situations? The more pro-investor ones, for sure, tends to happen when it's a tougher fundraising market. So what are the key takeaways? Liquidation preference definitely matters. You want to look at that term sheet and see which kind you have and what you're hoping for and what you want to negotiate for. To the extent you have that leverage is a 1X non-participating preferred. Do pay attention to how that stacks in later financing rounds. Work out some scenarios so that you can see what the return is for the founders and the team, or what hurdle you need to clear before you guys get paid at all. So liquidation preference, this is an important thing, and I hope that you focus on that one when you're looking at your Series A term sheet. Thanks a bunch. Hope this is useful to you, and if you enjoyed the episode, give us a 5-star rating and subscribe so that you can see updating episodes that come in the future. Thanks a bunch. The Tech Law Podcast is presented by Pillar Legal. For more information about tech, startup, and video game law, visit our website. Follow us on LinkedIn, Spotify, Apple Podcasts, or YouTube. Links are in the show notes. And now for the legal stuff. We are lawyers, after all. This podcast is for educational purposes only. The information presented in the show should not be construed as legal advice, and listening to the show does not establish an attorney-client relationship. In addition, the information presented has not been updated since the episode publication date. It may be required to be updated or customized for particular facts and circumstances. Any views expressed by guests are not necessarily the views of Pillar Legal. If you need help with any legal matter, be sure to consult an attorney. And if you don't have one, consider contacting us. This podcast episode may be considered attorney advertising under applicable law.